verdict on the penalty phase. And we're going to get to that in a moment. But before we get too far from what happened before we broke, I want to readdress that. I'm concerned in that Mr. Terry has made an allegation that his attorneys lied to him. That's exactly what he has alleged. And obviously there is an appropriate 3850 that can be filed and addressed, but the accusation is fresh. And I don't think that I should pass on the opportunity to make a perfect record as we're here. So I don't believe that I can order him. I gave him an opportunity to make any additional record that he wishes to, and I will continue to extend that opportunity to him if he wants to change his mind and put anything on the record. But I think that the most important thing is that I ask you, Ms. Perry, whether or not you promised him anything. And if that requires me to find a waiver of attorney-client privilege, I find that because he's alleged that you lied to him in order to get him not to testify in the guilt phase. And so I'm asking you, and I'm finding that it constitutes a waiver. In fact, I'm ordering you to tell me whether you promised Mr. Perry anything in exchange to get him not to testify in the defense case in the guilt phase of this case.
Since I've been ordered, I am permitted to answer. And no, of course I did not.
Okay, all right.
Judge, I apologize, but unfortunately, I don't know that Mr. Terry said that it was Ms. Perry that promised him. I'm just trying to play it out logically.
That's true. All right. All right.
So you could just ask Mr. Terry who it is that made the promise to him. And
I would ask that you instead perhaps just inquire of my colleagues if they made any promises. I don't.
Fine. Mr. Kane, did you make any promises to Mr. Terry regarding anything in order to, regarding his decision whether to testify in his case in chief during the guilt phase?
Yes.
You made promises to him?
Yes.
What were those promises?
I promised him that Ms. Perry's closing argument, any theories or any interpretations of the evidence would be based on the admissible evidence, and that she would argue according to the evidence that had been admitted in the case.
Okay.
That she could make no other arguments except what was supported by that evidence.
Okay.
That is the promise that I made.
All right. Any requests from the state at this point?
Judge, I'm deeply troubled by that answer. When a defense attorney stands up and says, yes, I made promises to a client who is now saying I was made promises and I waived my rights in furtherance of the promise, where Mr. Terry is now, I believe, if I understand things correctly, Mr. Terry is basically saying there was some agreement as to what exactly the story would be that would be told to the jury in closing, and that is not the story that was told. I don't know that this has clarified this any better.
Judge, I am answering the court's question. All right, there is more to the discussion on whether or not a client is going to testify than just what has been said here. And I don't know if now is the appropriate time to address that when we have the jury waiting to announce their verdict. So I would ask that any concerns that the court has on this issue be undertaken or addressed after we have received this decision by the jury.
Mr. Diaz, any requests from the state regarding clarification? I mean, this is...
Your Honor, I mean, you have decided that this constitutes a waiver of attorney-client privilege. It is an odd situation for me to suggest what the court should ask, because I don't know that I'm the appropriate person to ask the questions.
I'm asking if you have any suggestions.
Well, I mean, Judge, if attorney-client privilege is waived, I don't understand why you cannot ask the defendant what it is that he believes he was promised, and then you can ask the attorneys individually, did any of you promise that or anything even remotely in that realm? I mean, this is pretty explosive stuff that is...
I understand. I agree. I mean, it's somewhat even uncharted territory. But I appreciate your suggestion. Mr. Terry, I'm going to ask you what you were promised.
Sir, there were no theories discussed between my attorneys and myself in respect to any other sequence of events except what I described to them. Therefore, when it was told that everything would be covered in closing, I was under the presumption that what I had communicated to them would be communicated to the court instead of me testifying. So essentially, I looked at it as a way of them portraying what I had spoken to them in respect to the incidents that occurred that night for me in the closing arguments. And I thought the closing arguments were phenomenal up until the description of the incident, which was not accurate at all. Even though, as Mr. Kane described, it may have fit the context of the evidence, it was nothing close to what I had described to any of my attorneys.
All right. Mr. Kane, did you promise that?
No, I never promised Mr. Terry, ever, that what he had detailed for us previously would be theorized or argued by Ms. Perry. Never under any circumstances.
Okay.
As a matter of fact, my caveat to him was the promise we can make is that Ms. Perry's argument will be supported by the evidence, and the evidence alone, and her interpretation and reasonable interpretation based on what can be inferred from the admissible evidence.
But you did not specifically promise him that her closing argument would contain anything that he expressed to you regarding a theory of the case?
Under no circumstances did I promise that.
Okay, thank you.
And I do not believe that Mr. Terry is saying that I made such a promise.
Well, hold on. Ms. Perry, did you make any such promise to Mr. Terry?
No.
Ms. Spradley, did you make any such promise to Mr. Terry?
No.
Judge, I want to be respectful of the fact that we have a jury waiting. I really do, but
I opened this door, but I was concerned about an allegation of a defendant in a death penalty case that not only implied, but appeared to specifically allege that his attorneys had lied to him.
I agree, Your Honor. I mean, that's what I was concerned about at the beginning. He was basically saying I was promised something, and then they didn't give me what they promised.
Well, but the attorneys have now said that they did not promise that they would provide a version of anything that he relayed to him. They've all said that on the record. Is there anything additional you want me to ask them?
I mean, I thought that when Your Honor came out, and maybe I misinterpreted what you said, and if I did, forgive me, but I thought you were starting this with, you were going to ask the defendant specifically what it is that he thought was going to be said that was not said. If
I said I can't order him to do anything. I would give him the opportunity if he wished to put anything on the record. I did, after, end up asking him specifically in response to your suggestion that I asked him what he was promised. So that did change. And I asked him, and he told me. I will continue to give him the opportunity if he wants to put on the record what his version is, but his attorneys have specifically indicated, each and every one of them individually, that they did not promise him that they would provide a representation of what his version was in order to get him to waive, to not testify. That's what they've said.
Well, I would ask Your Honor, or at least I would guess I would ask Your Honor to tell Mr. Terry that he has this opportunity to say on the record whatever it is, whatever fact, specific fact that he thinks should have been said or was going to be said that was not said.
I said that I would, and I will.
And I'd also ask that you would clarify with him, I guess, why when the closing was done and Ms. Perry sat down, there was no issue raised in that moment.
Judge, the prosecutor may want to question Mr. Terry, but he doesn't have the right to. Those are not appropriate questions. This is not.
Well, I've already put on the record that he waited, that he didn't say anything about it until now. But I will give him the opportunity. Mr. Terry, if there's anything that you would like to put on the record now, we're making a record.
That was happening a few minutes ago. We're getting you into court because the jury's now entered the courtroom for the verdict, death penalty or life.
The jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. The bailiffs have indicated to me that you have reached a verdict in the penalty phase of this case. I'm going to turn now. Williams.
Yes, Your Honor.
Do you have the verdict form for the penalty phase?
Yes, Your Honor.
Could you please present that to the bailiff? Thank you, sir. I will review the verdict. I will then present it to the clerk to be published. Mr. Terry, if you will please stand with the counsel for the publishing of the verdict.
State of Florida versus Matthew Robinson Terry, case number 22 CF 006969. We, the jury, find as follows as to Matthew Terry in this case. A, aggravating factors as to count 1, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Matthew Terry was previously convicted of a felony involving the use or threat of violence to another person. Check. Only yes or no. Yes was checked. Number 2, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was especially heinous, atrocious, or cruel. Check. Only yes or no, and that answer was no. If you answered no to every aggravating factor listed, do not proceed to Section B. B, sufficiency of the aggravating factors as to count 1. The answer is no. Dated this 17th day of November 2022 in Hillsborough County. 4-person, signed by the 4-person WW.
Thank you, Madam Clerk. You may be seated. Would either side like the jury polled before they are released by the court?
No, Judge.
There.
All right. Anything else that we need to address before the court releases this jury? State?
Nothing, Your Honor. Thank you.
Defense?
Nothing, Your Honor. Thank you.
All right. Ladies and gentlemen of the jury, this is my final opportunity to address you. And the first thing that I want to say is one of the first things that I said to you 3 weeks ago when we brought you in here, and that is thank you for your very important civic duty. I indicated to you during jury selection that jury service is one of the most important things that you can do for your country, and I am quoting Abraham Lincoln. You have completed that very important service, and we greatly appreciate you. I know that it wasn't easy. I know that it was long. You've been here now for 3 weeks. Not only do I thank you, but I appreciate you, and I thank you for your patience with us. All of my prior restrictions regarding doing any research about this case, about discussing this case with anyone, I am going to release you of at this time. That means that as you walk out that door in just a moment, you are free to either continue discussing this case amongst yourselves, but also to discuss it with others. It is entirely your decision and your decision alone whether you wish to do that. If you do not want to discuss it with anyone else, you do not have to. Additionally, there is a very special protection that applies to your deliberations, both during the guilt phase and in the penalty phase. That is that you cannot be forced to talk about your deliberations except by court order. Again, though, that is your decision. If you wish to do so, then you may discuss with others your deliberations. As far as everything in the case, anything that may be out there on media, social media, you are free to look at that if you wish. I cannot say it enough, so I'm going to say it one last time as I dismiss you from the courtroom, and that is thank you sincerely. All rise for the jury. Jury has exited. Everyone may be seated. There are no options regarding sentencing. What is the state's request?
Your Honor, we'd ask to proceed to sentencing. The family is here from out of town.
All right. I don't see any reason not to.
Your Honor, can I just have a minute to confer with them?
Yes.
There's no legal reason, defense agrees.
Okay, thank you.
Wow, this jury did find life without parole. They found there was one aggravating factor, and that was that the state established that the defendant had been previously convicted of a felony involving a weapon. They did not find that the first-degree murder in this case, for which the defendant had been convicted, was especially heinous, atrocious, or cruel. The state asked for that. They didn't find it. As a result, as they filled out their very long verdict form, the sufficiency of the factors as to count one was no, meaning automatic life. They didn't get to mitigating factors because they didn't get far enough to have recommended death. They did not recommend the death penalty. You can see the emotion on the defendant's face. He's not been emotional before, and I just saw him thank his attorneys. You could watch him mouthing the words, "Thank you." We believe they're going forward with sentencing. Someone's standing. Let's see if we can get you back into the courtroom. All right, we don't have audio. Carlos, I'm going to cut you off rudely if we get audio because we don't want to miss any of the sentencing that they're going forward with now. But you said earlier you thought, oh, not a good sign. He's getting death, and yet life without parole. What do you think? What
do I think? Once again, back to my beloved state of origin, Florida never disappoints. It's interesting. I think to a certain degree they may have done a Solomon-esque decision by finding in one aspect that there was a prior aggravating circumstance, but in the other that there wasn't. And that probably originates from the fact that there wasn't enough time to have done the crime, in other words, to plan it out, to satisfy that aggravating factor, and it could be seen as a crime of passion. But it'll be interesting. I don't think this is the last we'll hear of Florida versus Terry.
Ooh, no, not with the issue raised. Maybe that was a Hail Mary because he knew he was facing death. But to accuse the attorneys of making a promise to him, causing him not to testify. We have audio. Let's go into court.
No chance.
And then otherwise we can proceed as
Yeah,
well.
absolutely, absolutely. Anyone who wants to address the court may. We're going to proceed to sentencing at this time, so she may come forward. We'll just put her at the podium there, unless she wants to come down to the witness stand, wherever she's more comfortable.
Ben, would you rather stand?
You want to go to the podium, or do you want to come sit in the chair?
I'll come sit in the chair.
All right, let me swear you in before you walk over there. If you'll face me and raise your right hand, please. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed to the chair. Did you want, I don't see any reason why you can't go with her. This is victim's assistance.
Yes. Can we just maybe set a chair up over here for her?
You want to just put that chair right over here? Is that sufficient? Is that all right with you, ma'am? And Mr. Diaz, I apologize. Please state her name again.
Yes, this is Christine Empey. E-M-P-E-Y.
Welcome, Miss Empey.
Thank you.
I'm going to allow Mr. Diaz the opportunity to ask you questions.
Miss Empey, just a little bit of background so His Honor understands. You are the stepmother of Kay Baker,
Yes.
and how long have you been her stepmother?
35 years.
All right, so that's the majority of her life.
Yes.
Do you have something you'd like to say here in court?
Yes, I do.
Please proceed.
What words did Kay say that night to justify you killing her? How bad could those words be? Did she say, Dad was right? Michelle was right? Was that what got her a death sentence? It is very unsettling as a parent to fear for your daughter because of the partner they've chosen. I feared for Kay's life. Her dad feared for Kay's life. And I don't understand why she did not. I hope you fear for your life.
Thank you, ma'am. Let me just see. Mr. Diaz, did you have any questions?
No, Your Honor, thank you.
Does the defense have any questions?
How sobering to hear that the stepmother of Kay Baker, the convicted killer she looked at, he was looking at her. I feared for her life. Her dad feared for her life. And yet she didn't, and she was murdered. We are going to take a break. Certainly when we come back, we'll continue to bring you the sentencing phase of Matthew Terry's case in the state of Florida.
Tonight on Closing Arguments, 4 students murdered, a manhunt underway, and a college community shaken to its core. We'll take a closer look at the victims and what police know so far. And Courtney Clenny back in court today seeking bond. The OnlyFans model has made millions, but now stands accused of murder. What we learned from today's hearing and what it all means for her trial moving forward.
Closing Arguments tonight at 8/7 Central, only on
8/7.
Breaking news, Matthew Terry, the jury did come back with a verdict for the sentencing phase. Life without parole, not the death penalty, life without parole. So no objections, the court moved right into sentencing. We just heard from the stepmother of Kay Baker, the victim, and guess who's on the stand now? You haven't missed it, we're gonna take you back in there. The convicted murderer's college girlfriend addressing the court. Let's see what she has to say.
Just want to thank you. Ma'am, could you please tell us how you know Matthew Terry?
I was his college girlfriend. We went to different colleges, but we dated almost 20 years ago.
Okay. And do you have something you'd like to say here to the court?
I do.
Okay, please go ahead.
Am I allowed to address Mr. Terry?
Yes.
Okay.
Objection, Your Honor. These proceedings are not to be having the witnesses address the defendant directly. The requirement is that they address the court. We didn't
I can do that as well.
first.
All right, go ahead and address.
I can do that as well.
Address me.
Okay. I have sat here this week and listened to everything that has happened, everything that has been said. I have watched the giggles and the laughs and the complete disrespect for a woman's life. That woman is not here today. She has passed away. And I feel like it's a slap in the face, especially when I heard that there were no priors, when you were given instruction that there were. I was not allowed to testify in any of this because I accepted misdemeanors rather than pushing for a trial in felonies. And because of that...
We end this for a second and approach.
I'm going to overrule whatever the objection is. I'll allow it.
If I could just have access to the record, please.
I'm sorry?
If I could have access to the record, please.
You can have it from there.
Yes, the access to the record is that the purposes of these proceedings with providing victim impact. My understanding is that Ms. Cook is now taking the opportunity to denigrate the defense and to criticize the defense without proper foundation. And we would just object to any further statements about the defense if she would like to confine her victim impact, not fully knowing the relationship that she may or may not have had with Kay Baker. We can then address the appropriateness of her taking a stand and making these remarks.
Your objection is noted. You may proceed.
Ma'am, just a little bit, because I think the judge may not understand what you're talking about. Were you the victim in another case involving Mr. Terry?
Yes, I was.
When was
Overruled.
When was that?
Early 2000s.
And can you just give a brief summary of what happened in that case?
Yes. He broke into my house. I was assaulted. My girlfriend, which was not in a lesbian sense, my friend that was a woman, was also assaulted. And he chased us around the house. When the police came, he pretended to be the victim rather than the assailant. And a lot of the things I heard today regarding Kay's, or not today rather, but this week, were very similar to the things that I endured. And so I did not plan on saying anything today. I did not plan on being a part of this at all. But I feel that Kay deserves that support. She trusted this man wholeheartedly. She has for years. I have known of Kay since we dated. She was a good person. She was a beautiful soul, and she loved this man wholeheartedly and would have done anything for him.
Is there anything else you'd like the court to know?
No, that was it.
Thank you, ma'am. Pass the witness.
Any questions?
No questions.
Thank you, ma'am. You may step down. Mr. Diaz, anyone else?
No, Your Honor, that's it for witnesses that we'd like to present.
All right, let me see if there's any witnesses from the defense.
No witnesses.
All right. And does Mr. Terry wish to address the court?
Yes, sir.
All right.
Your Honor, there's only one lawful sentence. I hate to say that you don't have discretion, but you don't have discretion, so I would just ask that you impose the lawfully required sentence.
Anything from the defense?
Nothing further.
All right. Yes, please stand. I guess in one respect, it is easy since Mr. Diaz is absolutely right and that I don't have any discretion. There is only one sentence. What I will say is that I listened to the testimony of Ms. Rogers both during the Williams Rule hearing and during the trial that we've been in here, and additional testimony regarding the charges, the trial, the sentence in Michigan. I don't know what happened in Michigan as far as the trial and the sentence, but based on what I heard, I believe that you should have been in prison in Michigan and that Miss Baker should still be alive. This is Florida. You're going to prison for the rest of your life. I adjudicate you guilty. I sentence you to life in prison. I impose all fines, fees, associated charges, and I advise you that you have 30 days to appeal the judgment and sentence entered against you. Thank you.
And the credit time, Judge?
He has 174 days credit. State, any objection?
No, Your Honor.
All right. Thank you all very much.
Mandatory life without parole. Julia Janae, who has been there live covering this, is joining us now live from Florida. Julia, the first thing I have to say is to hear an ex-girlfriend from college get up on that stand and say, well, I agreed to misdemeanors, but this happened to me and my girlfriend. This didn't just happen twice. Now we know at least 3 times.
Judge Ashley, it opened your eyes to what was really going on behind the scenes, that this was a repeated thing. It was a pattern. And not until now do you see something with finality happening to this defendant. Judge Sabella said it in such a passionate way that it sent chills down my spine when he just said that he doesn't know why he was released when he was in Michigan, but this is Florida and he's spending the rest of his life behind bars. Amazing that it took this long, but now finally justice for all of these victims.
Justice for all of these victims. And Julia, if ever there's a case where I think if he did get out of jail, he'd do it again, it's this one. After everything we've heard, all of the evidence, the jury coming back, convicting him appropriately of this, it's wow. And speaking of wow, let me...
Right? It's been proven.
It has. So Julia, let me ask you your takeaways when the jury came back in to say life without parole, but not recommending the death penalty.
Well, you know, life without parole is the default. So no matter what they did today, if they didn't recommend the death penalty, then it will automatically be life in prison without parole. I listened to the lead up to life or death, because I know that's a difficult question to ask any jury. And regardless of how they feel about the evidence, sometimes it just comes down to mercy or not. But in this case, they didn't even find that the prosecution had proven this was a heinous act, that it was cruel and atrocious, which you don't often hear. We mostly hear that juries feel that prosecutors have proven that these crimes are heinous and atrocious and cruel. But they didn't find that here, and they didn't find that the mitigators did not outweigh the aggravators. So they found the mitigators outweighed the aggravators. So coming back with that life in prison without parole. But hats off to this jury. They were the most efficient thing about this trial through the last 3 weeks.
And how did the courtroom react, the family, the people in the gallery, to the jury verdict of life without parole versus a recommended death penalty?
Very still. It was very quiet inside of that courtroom. You almost didn't see any reactions, any movement, any shuffling from anyone when it was read. Very different from the guilt phase, when we didn't know whether it was going to be guilty or not guilty. I saw them clasping each other's hands and almost shaking, waiting to hear the verdict read. This was a much different situation. I asked another ex-girlfriend, Michelle Rogers, when I interviewed her yesterday, whether she had an opinion on life or death in this case after she had testified against Matthew Terry, and she said she didn't have an opinion. At this point, she's safe, her kids are safe, so whatever happens, it happens. And you got the sense that that was how this family felt as well, because initially this was not going to be a death penalty case, and prosecutors had cleared it with the family before they decided not to go forward with the death penalty. But then that did change before the deadline was up, and this became a death penalty case.
All right, Julia Janae live, thank you so much for joining us.